The unsung hero of the secured party process, your trust. An alternate title to this video could be How to Own Your Stuff. Civil law, a body of rules that delineate private rights and remedies and govern disputes between individuals in such areas as contracts, property, and family law, distinct from criminal or public law. Underlying all civil law is something called in rem jurisdiction. In rem meaning against things, practiced in maritime law or admiralty law, which exclusively governs activities at sea or in any navigable waters. The opposite of in rem is in personam, meaning against persons, which the courts are well aware of. However, it is the action in rem which, practiced only in maritime law, stealthily operates in every civil and criminal court. 1783, Gregson versus Gilbert. A slave ship's captain's grave error extends a seaward journey for which there was not enough sustenance or water. 60 Negroes died for want of water, and 40 more, through thirst and frenzy, threw themselves into the sea and drowned. The masters and mariners, in preservation of their own lives and of the rest of the Negroes, were obliged to throw overboard 150 other Negroes. This case was handled in rem jurisdiction because the Negroes were in rem. They were considered things. Government doesn't have jurisdiction over humans, but it does over things. They were flesh and blood men and women, but they were slaves. They were property. They were cargo. They had been labeled. Government can only gain a fictional in rem jurisdiction over men by creating various legal devices, or personas, for those men to assume limited control of. Examples of these legal devices are such labels as person, citizen, taxpayer, driver. These are things subject to corporate federal in rem jurisdiction. This device, or trick, is a legal fiction, a falsehood made true by force of law, and it is in fact a legal object or res, like a person, citizen, taxpayer, driver, or resident, like a slave. Whose slave are you? Who has the jurisdiction to throw you off a ship? Who has the right to throw you in here for any incident called a crime that has not resulted in a flesh and blood victim? The government can throw you into anything if you are a thing. The 1868 14th Amendment to the Constitution of the United States granted citizenship and equal civil and legal rights to African Americans and slaves who had been emancipated after the American Civil War. It did so by including them under the umbrella phrase, all persons born or naturalized in the United States. The reality is, the 14th Amendment didn't free any slaves. It created millions more out of the men and women who were persons born or naturalized in the United States. The 14th Amendment labeled all Americans as citizens, subjugating them to in rem jurisdiction in lex mercatoria, or merchant law, the law at sea, operating on land. This situation is also known as slavery. When FDR bankrupted the United States of America Corporation in 1933, all 50 state franchises pledged the good faith and credit of their states and citizens thereof. In other words, hundreds of millions of Americans were falsely presumed to be acting as United States citizens and became sureties responsible for paying off the debts of a mostly foreign-owned private corporation since 1933. The 50 state franchises then created millions of Sestake v. trusts using the names of living flesh and blood men and women, and used these to seize everything we own, including our very name, our patents, copyrights, our land, our homes, our businesses, and our very bodies. In a nutshell, our identities have been stolen to promote fraud and false claims in commerce against us. John Henry Doe is the title of a Sestake trust. Your name in all capital letters, dog Latin, the language of the dead. It is a deception and it constitutes fraud. The goal of the banking cartels and the agencies they control, such as the IMF and the Federal Reserve Private Bank, has been to defraud and mischaracterize Americans as United States citizens and/or citizens of the United States, then tax, coerce, and charge us under false pretenses, then mount a claim on abandonment, in effect saying that our states of the Union no longer exist and that we've all volunteered to give them everything in sight in exchange for the benefits which, by the way, you pay for. Are we having fun yet? All United States offices, officials, and departments are now operating within a de facto status in name only, under emergency war powers. With the constitutional Republican form of government now dissolved, the receivers of the bankruptcy have adopted a new form of government for the United States known as a democracy, being an established socialist communist order. As a citizen of the United States communist government, you are a civilly dead entity operating as a co-trustee and co-beneficiary of the PCT, the Private Constructive Cestui Trust of U.S. Incorporated under the 14th Amendment, which upholds the debt of the USA and the U.S. Inc. A citizen of the U.S. is civilly dead and cannot become a real party in interest to any action. Hypothecation, civil law. This term is used principally in the civil law. It is defined to be a right which a creditor has over a thing belonging to another, and which consists in the power to cause it to be sold in order to be paid his claim out of the proceeds. You have been hypothecated. If the government can legally take your property, be it the funds in your bank account, your car, house, land, or your children, even your own body, how can you possibly say you actually own these things? 19th century slaves did not own their bodies, and they did not own the things they used. Even their children were considered the property of the masters, and they could be taken away from them and given to someone else. This is what is happening in America today. So now how can you secure your assets and make sure the government won't touch them? First of all, you withdraw that consent in a very big, very moral, very public way by becoming a secured party, but also by becoming a private man or woman operating in commerce. With the secured party process, much focus is given to the UCC, the Uniform Commercial Code, and the UCC-1 financing statement, which the natural man will use to inform his straw man and its ill-begotten mishandlers that he has a financial interest in the debtor straw man's personal property. This is already your property in the real world, but it belongs to a make-believe corporation so far as they have magically created statutes and codes to make it so, and to which you consent by not vitiating their presumptions about you and your property. The powerful documents you will file on a UCC-1 go on the public record so the world and the government can see that you have withdrawn the consent you gave through tacit acquiescence and that you have now officially removed yourself as a 14th Amendment indentured servant. You are now managing your own affairs and practicing self-determination, no longer beholden to the power-hungry, disillusioned, usurping psychopaths who hallucinate power unto themselves to determine what is right and what is wrong on a day-to-day basis. Becoming a secured party means you waive beneficial interest in the trust the de facto government created using your name when your oblivious mother signed your birth certificate. When you become a secured party, this and many more invisible adhesion contracts that you sever are clearly spelled out in the legal notice and demand in your UCC filing. This is from the secured party's legal notice and demand. The similarity in the names of the undersigned and the vessel in commerce, two distinct and separate legal entities, is testament to the undeniable propinquity. John Henry Doe Trust, originally an incorporeal creation of government parents, is dependent upon and only exists because John Henry Doe, a natural man, exists as a living, breathing, flesh and blood sentient being. The government, being an incorporeal entity, can only engage another incorporeal entity, and not a real flesh and blood human, and therefore the creation of a vessel in commerce known commonly as John Henry Doe Trust was highly advantageous to government to interface with. In reality, it's the only way government can interface with you. And it looks like this. On the left, you've got Natural Man, John Henry Doe, and on the right, you've got the vessel in commerce, John Henry Doe, the all capital lettered named entity, the fiction, the cartoon, which the government can interact with to get through to you. You are John Henry Doe, all capital lettered name, is the transmitting utility seen here in the middle, represented by the straw man. The government, the fiction, the incorporeal entity, cannot interact with B, the real man. If you want to learn more about this and how your all capital lettered name represents a legal entity, also known as a straw man, see my video titled Beat Your Straw Man and Then Control It, video number 43. There is a link in the description box. Now, because this is an understandable concern to many, when you waive beneficial interest in the trust to take up the abandoned position of trustee, you are not waiving the benefits you might be receiving because they are not really given to you, though you make use of them. They are given to the trust, the straw man, which is why all your checks and bills and anything from the IRS or the terrorist organization called government uses all caps for your name. If you have Social Security or disability benefits, those fiat debt notes will still come to you. By the way, calling the government a terrorist organization is not my opinion being injected into this video. I am calling the government a terrorist organization because the government is a terrorist organization. The name of the trust is your name in all capital letters, which is nothing more than a symbol, because there are no grammatical provisions in the English language whereby words and names in all caps are correct. It signifies a trust, which they deprived you of the right to be the trustee for, and instead usurped your estate and reduced you to a mere caretaker of your own assets. They did this deceptively without informing you. Taking up position of trustee of your trust is the first step in the secured party process. It will privatize the trust under your control, thereby taking it out of the control of that entity calling itself a government, which is what kind of organization? That's right. You will now be the trustee, managing your own affairs, operating privately in commerce as a transmitting utility without liability. And what happens when you die? With your trust in place, your successor trustee will not have to go to court, will not have to go through probate, and will not have to hire an attorney to disperse your estate. Why would they? The estate of a flesh and blood man or woman doesn't require permission from the government to disseminate private property between beneficiaries. No laughable death taxes, no estate taxes, no court fees, no extortion, no having to entangle yourself with criminals who support and profit off an incorporeal system designed to suck the wealth out of real men and women and their families and to transfer it to the super rich. Your beneficiaries keep everything that is rightfully theirs without government involvement. The most sophisticated trusts have been used by the wealthiest people in America, and they are really nothing more than a contract and a declaration of trust. It is an express trust created by the will of the settler while he is alive. It could be considered a living trust, but not in a statutory sense. Statute, a law enacted by a legislature. For example, color of law. A decree or edict as of a ruler, void on its face. To ordain, enact, decree, or established. By what authority? Here's an example of a statutory law. And another one, which begs the question, who gave the state the authority to tell you what you can and can't do with your own body? And here's a better question. How is it possible that anybody can grant authority to anyone else to have authority over others? On that note, you should always buckle up. A trust brings together the elements of contract and agency. U.S. Constitution, Article 1, Section 10, no state shall enter into any treaty, alliance, or confederation, grant letters of marque and reprisal, coin money, emit bills of credit, take anything but gold and silver coin as a tender in payment of debts, pass any bill of attainder, ex post facto law, or law impairing the obligation of contracts, or grant any title of nobility. Your trust is a contract that cannot be impaired. Smith v. Morse. It was held that any law or procedure in its operation denying or obstructing contracts' rights impairs the contractual obligation and is, therefore, violative of Article 1, Section 10 of the Constitution. Because the express trust is created by the exercise of the natural right to contract which cannot be abridged, the agreement, when executed, becomes protected under federally enforceable right of contract law and not under laws passed by any of the several state legislatures. According to the Supreme Court in Marbury v. Madison, anything contrary to the Constitution is a mere nullity. It purports to settle as though it never existed. So if a state passes a law that nullifies your inherent right to contract, such as create a trust, it is null and void, and such a law should be ignored. Which reminds me of People versus Battle. Persons faced with an unconstitutional licensing law which purports to require a license as a prerequisite to exercise of right may ignore the law and engage with impunity in exercise of such right, such as the right to travel. From a secured party's UCC filed legal notice and demand, the vessel in commerce known as John Henry Doe, initially created as a trust by the government parents for the benefit of the undersigned, John Henry Doe, as beneficiary on birth date, on the date of the creation of your trust, a waiver of beneficial position was declared to take up the abandoned post of trustee secured party Bailey to manage the affairs of John Henry Doe Trust, for the benefit of beneficiaries therein after named in Registry of Trust for the following reasons. Matters are not being handled with efficiency. In many respects, matters are not being taken care of at all. Usurpation of funds is occurring. There is rampant fraud and deceit. Position of trustee has been left vacant or uncontested. If a guardian behaves fraudulently to his ward, he shall be removed from the guardianship. That's Bouvier's Maxims of Law, 1856, what I call common sense. From Weiss's Concise Trustee Handbook, Trust Basics, first it must be understood that any trust, regardless of the many designations applied to them, is, in its most basic sense, a property interest held by one person, the trustee, at the request of another, the settlor, for the benefit of a third party, the beneficiaries. Express or written trusts put the legal estate entirely in one or more persons, while others have a beneficial interest in and out of same, but are neither partners nor agents. This simple, adequate, common law right, any person or group or person sui juris of his own right may exercise, the trustees issuing certificates of beneficial and capital interest divided into shares, as well as issuing bonds and other obligations as freely as they open a bank account, have a passbook, and draw and circulate checks, or make whatever contractual relations are allowed to persons as a natural right. What this means is, no government allowed. Elliott versus Freeman. The court made it clear that the express trust is not subject to legislative control. It went further to acknowledge the right-wise stance of the United States Supreme Court that trust relationship comes under the realm of equity based upon the common law right of contract and is not subject to legislative restrictions as are corporations and other organizations created by legislative authority. Those would be incorporeal entities. To clarify the equity and common law distinctions, the basis for express trusts under the common law in this instance is not that such organizations are creatures of common law as distinguished from equity, but that they are created under the common law of contracts and do not depend upon any statute. In the case of Shoe and Leather National Bank, the court held with regard to the promissory note made by the trustees under such limited liability That was not within the power of the court to change the trust liability on the note into a personal one of the trustees. That liability on a contract must be determined by the terms of the contract itself, and that a contract entered into under such limited liability, be it a note, agreement, etc., cannot be converted into one under personal liability law. And at Secured Services Co., the first thing we do for you is to set up your trust. It is the beginning phase. From a secured party's declaration of trust, trustees shall be empowered to hold securities in their own names, the name of a nominee, in street name, or unregistered in such condition that ownership will pass. Trustees shall incur no liability to the company for any loss. The trust shall indemnify the trustee from all liability. Further, any securities firm or commodities traders may rely on this document and the trust provisions herein in respect of a trustee's authority without making further inquiry. Trustees shall collectively act by authority of this contract and the trust provisions contained herein as a board of trustees for the purpose of holding and administering company assets for the benefit of certificate holders. The signing and acknowledging of this contract by any trustee or trustees shall constitute trustees' collective acceptance of this contract and its trust provisions, and trustees' acknowledgement that this organization's property and assets are vested in fee simple in the trust estate without any further act or conveyance by the Board of Trustees. Trustees as discretionary fiduciaries shall hold legal and equitable title to all assets. Trustees shall have general common law powers over the company and the trust estate herein, and may do anything any citizen may lawfully do in any state or country. Specifically, but not by way of limitation, they shall have all rights, authority, and power as follows, among many things. To manage, invest, and reinvest the trust estate, or any part thereof, in any kind of property or venture which men of prudence, discretion, and intelligence consider on their own account, without being restricted to investments which are ordinarily permitted by law or customarily used for trust funds, and without restrictions as to the duration of this organization. Specifically included, but not by way of limitation, are real estate, collectibles, gems, artworks, precious metals, corporate obligations of every kind, preferred and common stock commodities, mutual funds, and trust funds. Purpose and intent of this agreement. This contract with trust provisions is intended to create a common law contractual company, also known as an unincorporated business organization, for receiving, conveying, or holding property in fee simple, and providing prudent management of such property, and for conducting any legitimate business through appointed trustees for the benefit of certificate holders. Trustees shall hold both legal and equitable title to the trust estate, and shall act solely within their powers as provided herein and within their common law rights and immunities. Common law organization. Creator expressly declares this to be an organization founded upon the freedoms and rights inherent in the common law of the Republic of the United States of America, and all references herein to the United States shall be construed to refer to the continental United States of America in its original context as set forth in the Constitution of the United States, the original Bill of Rights, and the state constitutions of the several sovereign states comprising the Union of the United States of America. This organization, then, is created under the common law of contracts, protected by Article 1, Section 10, Paragraph 1 of the Constitution of the United States. It is therefore not created under the statutes of any U.S. state and does not depend upon any statute for its existence. It is not a partnership or corporation or statutory trust, but a separate legal entity having its own common law identity. Privacy. This organizational document and all company business shall be kept private, protected by the Privacy Act of 1974, the Fourth and Fifth Amendments to the Constitution of the United States, and the common law privacy rights available in the United States of America and every other applicable jurisdiction. Now you know why you never hear anybody talk about trusts. And the IRS will liken trust to a corporation like Walmart or McDonald's, or the US government, or like the IRS. And for that matter, like the Federal Reserve System, the Fed, U.S. central banking system comprising of 12 regional central banks called the Federal Reserve Banks, owned by private banks. And if you do hear of mainstream media ever talking, or government ever talking about trusts, they'll probably be statutory trusts, and they'll tell you to get a lawyer. And trust me, CIA-trained Anderson Pooper Scooper has plenty of trusts protecting his riches. The Declaration of the Express Trust. The Declaration of Trust is the trust instrument that constitutes the trust. A trust may be, and often is, formed out of a simple agreement or even a will. But with an express trust, the declaration has been preferred since the beginnings of trust under the common law of England, which otherwise shunned fictions of law. When all is done properly, obviously, there can be no lawful impairment of the obligations of a contract. This is from the security agreement in the trust of a secured party. Collateral. The collateral to which this security agreement pertains to is herein described below as personal and real property of trust. The collateral is now owned or possessed and includes property hereafter acquired by trust, in which trustee secured party now holds all security interests. Trustee secured party retains all rights of use, including but not limited to all principal, interest, proceeds, products, accounts, fixtures, and the orders therefrom. All claims of trust are secured interests released to trustee secured party for management thereof. Before any of the herein itemized property can be dispersed, exchanged, sold, tendered, forfeited, gifted, transferred, surrendered, conveyed, destroyed, disposed of, or otherwise removed from trust possession, settlement with trustee secured party must be satisfied in full, and acknowledgement of the same completed to the satisfaction of trustee secured party. And the collateral clarifications cover everything from agreements and addendums to all assets, including all gains, proceeds, equity, capital, accounts, receivable, derivatives, depreciations, inventory, materials, products, goods, and services, even your Lamborghini. But also, the trustee secured party herein claims all collateral and rights of trust attached to everything, from bank accounts to pension plans to tricycles to DBAs to plants and seas. So don't worry, nobody is going to touch the contents of your junk drawer. Your circus ostrich and the Davenport you inherited from Grandma are safe and sound. So are your hammer and nails. And for those of you who do not file the voluntary income tax, your life savings is protected. And for those of you who do volunteer to give the IRS the fruit of your labor, whatever is left over is also protected. Even your bumper stickers and anything you put on your automobile to raise awareness are protected by your trust. And so is cryptocurrency. On a side note, for non-SPCs that hold crypto, our trustee services business can create a trust especially for your cryptocurrency. If you want to learn more about the handlers of the estates of unsecured parties, see my video, Who is Handling Your Estate, video number 44. There is a link in the description box below. Let him who would move the world first move himself, Socrates. So if you want to reorganize your legal trust name and protect your assets from government theft and or confiscation, and if you believe you have the right to actually own yourself and your property, please come visit us at securedservicesco.com. Become a secured party with us, refer a friend or family member, and when he or she signs up, we will be writing you a check for $100. We hope to see you soon at securedservicesco.com. Thanks for watching.